We need to talk about Stephen Miller and plenary power. Let's go.
God, quit shooting at me! Quit shooting at me! You see they shooting at us!
According to Cornell Law School Legal Information Institute, the definition of plenary means full, complete, or absolute. It describes authority, power, or sessions that are unqualified or unrestricted in scope. For example, a person or body with plenary authority over a project has complete and final power to act on all matters related to it. Similarly, a plenary session refers to a meeting attended by all members of a group or organization, typically to make decisions that apply to the entire body. Now, this next bit of information comes from the Google AI overview, which I'm going to be honest, I don't really like using that, but it's citing its sources from that same Cornell website and from Wikipedia. It goes as follows. Plenary power means complete, absolute, and unrestricted authority over a specific subject, allowing a governing body or individual to act without needing further authorization, often seen in U.S. law regarding Congress's power over Native American affairs or immigration. Derived from the Latin word for full or complete. It signifies total control within its domain, though still subject to constitutional limitations. Now, what does all of this have to do with Stephen Miller? Let's let him explain it to you.
Thank you so much for joining us, by the way. You've called the district judge's ruling blocking the deployment of National Guard in Oregon legal insurrection. Does the administration still plan to abide by that ruling?
Well, the administration filed an appeal this morning with the Ninth Circuit. I would note the administration won an identical case in the Ninth Circuit just a few months ago with respect to the federalizing of the California National Guard. Under Title 10 of the U.S. Code, the president has plenary authority.
Stephen? Stephen? Hey, Stephen, can you hear me? It seemed, Stephen, I apologize. It seems like we're having a technical issue. We'll try to fix that and get back to you after a quick break.
Today at 12:06 a.m., January 14th, 2026, having 1.3 million views, Stephen took to the Homeland Security page on Twitter to write, "Reminder, to all ICE officers, you have a federal immunity in the conduct of your duties. Anybody who lays a hand on you or tries to stop you or tries to obstruct you is committing a felony. You have immunity to perform your duties, and no one, no city official, no state official, no illegal alien, no leftist agitator, or domestic insurrectionist can prevent you from fulfilling your legal obligations and duties. The Department of Justice has made clear that if officials cross the line into obstruction, into criminal conspiracy against the United States or against ICE officers, they will face justice." A lot of us are having problems trusting the media right now, and that's not exactly hard to understand. We seem to have this big fight online about left versus right. It's not that, it's up versus down and all of these things. But I implore you to let's look deeper. Anyways, let's look deeper. Let's go right to the code itself. U.S. Code Title 10, 1901, Congressional Findings. Recognizing the special relationship between the United States and Indian tribes and their members and the federal responsibility to Indian people, the Congress finds that 1. That Clause 3, Section 8, Article 1 of the Constitution provides that the Congress shall have the power to regulate commerce with Indian tribes. And through this and other constitutional authority, Congress has plenary power over Indian affairs. 2, that Congress, through states, treaties, and general course of dealing with Indian tribes, has assumed the responsibility for the protection and preservation of Indian tribes and their resources. 3, that there is no resource that is more vital to the continued existence and integrity of Indian tribes than their children, and the United States has a direct interest as trustee in protecting Indian children who are members of or are eligible for membership in an Indian tribe. 4, that an alarmingly high percentage of Indian families are broken up by the removal, often unwarranted, of their children from them by non-tribal public and private agencies. An alarmingly high percentage of such children are placed in non-Indian foster and adoptive homes and institutions. And 5, that the states exercising their recognized jurisdiction over Indian child custody proceedings through administrative and judicial bodies have often failed to recognize that the essential tribal relations of Indian people and cultural social standards prevailing in Indian communities and families. What does this have to do with Stephen Miller, you're asking again? Well, here in Minnesota, we're not assholes. We were supposed to be recognizing a treaty known as the 1854 Treaty, which was supposed to cede a bunch of land to Native Americans up in the northeastern corner of our state. In 1854, the Chippewa of Lake Superior entered into a treaty with the United States whereby the Chippewa ceded to the United States ownership of their lands in the northeastern Minnesota. These lands are called 1854 ceded territory. Article 11 of the 1854 Treaty provides, and such of them as reside in the territory hereby ceded shall have the right to hunt and fish therein, until otherwise ordered by the President. The Chippewa of Lake Superior who reside in the ceded territory are the Fond du Lac, Grand Portage, and Bois Forte bands. And here we have an Oklahoma law review by one David A. Martin from the University of Virginia, titled Why Immigration's Plenary Power Doctrine Endures, from 2015. In the abstract of this law review, it states, the plenary power doctrine, traditionally traced to the Supreme Court's decision in Che Chan Ping, has persisted despite a steady and vigorous stream of scholarly criticism. This essay undertakes to explain why. First, the court's strong defense to the political branches does not derive from the concept of sovereignty. Justice Field's opinion for the court invoked sovereignty not to trump the rights to claim, but to solve a federalism problem, structural reasoning that locates the immigration control power squarely in the federal government, though not explicitly enumerated in the Constitution. The other day I posted a video where I talked about the Insurrection Act here in Minnesota and how Donald Trump is basically looking for any reason at this point, I believe, to use it. I now believe that that's Plan A, and I think that Plan B is plenary power. I'm not going to sit here and try to convince you on Stephen Miller, whether he's a good or bad person. I'll just pause the screen here so you can take a look for yourself. According to the University of Alaska Fairbanks on the U.S. Constitution and Congress, it cites the power that Congress has over Indian tribes is very broad and is often referred to as, quote, plenary power. Plenary power means that the Congress has the same power and authority over Indian affairs as states have over the affairs of their citizens. Congress can limit, modify, or eliminate powers that the tribe possess. Congress can even terminate tribal status. The plenary power of Congress essentially keeps the states out of Indian affairs. Congress exercised its power over Indians early on by enacting several statutes. Congress placed Indian affairs under a newly formed Department of War, set aside money to negotiate Indian treaties, and appointed federal commissioners to negotiate them. Congress passed a series of laws regulating commerce between Indians and non-Indians, beginning with a law which prohibited states and individuals from buying Indian lands, Indian Non-Intercourse Act of 1790. Congress extended the federal jurisdiction over general crimes when non-Indians were involved in the Indian country from the General Crimes Act. These early laws of Congress are still in effect today. The last piece we're going to reference here is from the University of North Carolina Law Review, entitled Plenary Power in the Modern Administrative State. As we turn towards the conclusion, a retreat from plenary power principles rooted primarily in delegation concerns falls short of the ultimate goal of recognizing full constitutional protections to non-citizens because it fails to constrain the power of Congress and the president. Even where the relevant decision maker isn't an administrative officer, a non-delegation theory of plenary power may be as likely to reject any agency decisions favorable to non-citizens' interests as those that harm them. The court emphasized the, quote, undoubted right of every society to determine who shall compose its members, apparently concluding that the policy, as represented by political branches, must be free to define the terms of its membership without judicial interference. As the court in Che Chan Ping put it, for local interests, the several states of the Union exist, but for national purposes, embracing our relations with foreign nations, we are but one people one nation, one power. The decisions of Congress and the President, constitutionally vested with the authority to regulate foreign relations, are more likely to cohere as a national uniform policy as compared to the decisions of various states and federal courts. The same cannot be said, however, of the granular decisions of the low-level immigration officials. The diffusion of authority across our nation's vast and sprawling immigration bureaucracy precludes any claim that vesting plenary power in agencies will improve uniformity. For many who hoped that the shifts in immigration law would ultimately lead to the recognition of full constitutional protections for non-citizens. However, the non-delegation theory of plenary power does not go nearly far enough. First, it continues to deny meaningful judicial review when Congress or the President violates non-citizens' rights. Second, although courts may exercise robust review over the decisions of agency officials, such review may be as likely to reverse immigration decisions that protect aliens' interests as those that harm them. The non-delegation theory of plenary power continues to shield immigration decisions rendered directly by Congress or the President from meaningful judicial review. These institutional actors remain free to exclude, detain, and deport aliens regardless of the extent of which such decisions violate other constitutional norms. And while the vast majority of immigration decisions are made by the agency officials and thus remain subject to judicial review, Congress and the President have been responsible for some of our nation's most troubling immigration policies. And in conclusion, the much maligned plenary power doctrine, which categorically insulated immigration decisions from ordinary standards of judicial scrutiny, has been in decline. Contrary to conventional wisdom, this retreat may be less rooted in judicial solicitude towards non-citizens' rights than a growing concern regarding the breadth of policymaking power exercised by our nation's administrative agencies. This observation sheds new light on the scope and limits of the plenary power doctrine today. It suggests that the court will retreat plenary power principles to exercise meaningful judicial scrutiny over immigration decisions made by agency officials, which constitute the vast majority of immigration decisions today. However, plenary power principles appear to remain intact to insulate immigration decisions rendered directly by Congress or the President from meaningful review. Moreover, even where the relevant decision maker is an administration official, close scrutiny over immigration decisions may be as likely to reverse policies designed to protect non-citizens' interests as those designed to harm them. So what are your thoughts on Stephen Miller or Little Voldemort or whatever you want to call him? I think this is his backup plan. I think that the Trump administration has continuously used fragile at best legal framework to do the things that they've been doing. And I do think that this is their backup plan, if you will. I want to hear from tribal leaders. I want to hear from adults who have been in law. I want to hear from real people that have really dealt with this stuff, particularly the tribal leaders, because I have a feeling that you guys understand these laws very well. As a white person, I can tell you flat out, I had no idea about these laws. So make sure to like and subscribe and comment and all that crap. We'll see you next time.
Quit shooting at me! Quit shooting at me! You see, they're shooting at us!